Okay. Thank you, and hello, everyone. Thank you for joining today's webinar. Today's session is brought to you by the Office of Small Business at Prosper Portland, the central point of entry for Portland small businesses. And Shana, do you mind getting to the next slide, please? Thank you. We're here to support you with questions about accessing City of Portland services, navigating Prosper Portland programs, or finding local resources. And next slide, please. Thank you. You can connect with us anytime at pdxofficeofsmallbusiness.com. I'll put it in a chat as well, or by calling us at 503-241-4594. And now I'm excited to turn it over to our presenter, Shanna Knight from the Small Business Legal Clinic at Lewis & Clark. Thank you, Shanna.
Thank you. Thank you also everyone who's able to attend, whether live or during the recording. I really appreciate your time, and I'm really excited to talk about copyrights. Whether you're looking for a copyright for yourself, for your business, or whether you're interested in posting or using copyrighted material, this can be a really important part of your intellectual property. And so I'm happy to talk more about that. As an attorney, of course, I've always got to have some disclaimers. This presentation is general only and for educational purposes. It is not legal advice. Neither the Small Business Legal Clinic nor the speakers are your attorney. And if you have specific circumstances, perhaps you want a copyright registered or you have questions about something to make sure you're not infringing, please speak with an attorney about your specific circumstances. Today, we are going to talk about your learning objectives, a little bit about the Small Business Legal Clinic, and then we're going to dive right into copyrights. And we're also going to talk about some of the more recent ongoing issues with copyrights and artificial intelligence. So your learning objectives today are to kind of figure out what is and is not protected by copyrights. Not everything can be copyrighted. Ways to protect your copyrights from infringement, and also how artificial intelligence is just complicating everything and what to do about it, especially if you are a creative who's interested in protecting your work. The Small Business Legal Clinic provides transactional legal services to low-income small businesses. The services we provide include helping form your legal entity for it to be a business, reviewing contracts for you, writing contracts for you, helping you on employment issues, assisting you through intellectual property contracts, registrations, including copyrights, and as well as navigating the regulatory landscape. So with all of the introduction material out of the way, let's go ahead and dive in. I want to say that I welcome your questions. If you have any questions, please feel free to go ahead and put them in the chat. We'll be monitoring those. You can hold your questions to the end if you like, but I much prefer to have them while we're going on the specific slides. If you have a question, you're not the only one with this question, so other students will appreciate that you've asked the question. And then also, I can expand more while we're talking about that topic and you don't forget your question at the end. So please feel free to interact and send your questions in as they come up. Okay, so if you were at the presentation last month when we talked about just intellectual property, trademarks, copyrights, patents, and trade secrets, you probably have seen this slide before, but I do want to talk about what on earth do copyrights even protect? And so as the law is concerned, they want to protect original works of authorship fixed in any tangible medium of expression. And that is a mouthful, and it's kind of hard to parse that out. So let's just talk about what that means. So the legal triggers for copyright are fixation. If you have a creative idea in your head, it is not fixed. It is not ready to be copyrighted. However, if you have put a painting on a canvas, if you have put a design into like Adobe Creative or Canva or your creative program, if it's something that is fixed on any medium of expression, whether that's clay, whether that's music written, handwritten on a page, on a napkin even has been held to be fixed. It has to be out of your head though and onto something that you could email to yourself or put into a program or hold in your hands. Then the next legal trigger is originality. So it has to be something that you creatively kind of came up with, whether it's a story or whether it's music or whether it's art or new software or a website. If it is, um, something that you've copied from someone else, that's not really original. If you've taken influence from someone else, that could still be original work. But copyrights really focus on this creative expression. So I will be like using the word, referring to that phrase, the creative expression, a couple of times. And the reason why is because we want to look at this original creative expression, but do understand that copyrights do not protect the facts expressed. I will go into that a little bit more, but I have definitely had clients who will come in and they'll have forms, for example, and they want to copyright them. And generally, forms are not copyrightable. So unless they're very creatively put together with lots of color, maybe artwork, that could be something that's protectable. But generally, facts are just not protected by copyrights. Um, it's unless you're really doing something creative with them. There are a couple of exceptions as well to copyrights that we will go more into, including fair use. For example, I've got a couple of things up on the screen right here that are definitely copyrighted. And I'm not selling them to you. I'm not trying to give you the film or the book. I'm just using these examples, and this is something that falls under fair use. We'll go more into fair use too, where you're not going to be sued for copyright infringement if you use copyrighted works in certain ways. There's also what comes into the public domain. So copyrights don't last forever. We'll talk about the time frame, but in 2025, works that were published back in 1929 have come back into the public domain, and this includes things like newer iteration, like the very first time I think Mickey and Minnie Mouse, for example, were put together in a cartoon. Those particular drawings of them, like since then, right, Disney has updated their drawings and changed things. Those might be new copyrights. But the original things that came in, there's like some films, um, some books, of course, music and writing, and I think it's the Duke University actually has a page that you can go online and look it up. And they do a big celebration like every January 1st to celebrate all of the new works that are coming into the public domain. They are no longer protected by copyright. And these are things that you could use in your materials without limitation, and you're not going to be subject to copyright infringement. So let's talk a little bit about the goals of copyright protection. We have a couple of different goals, and basically the recipient are going to be, making sure that we serve the creators of the work, whether it's art or music or including creative works of software and things like that, and also protecting society. So having copyright protections encourage new and useful work, because if you do new and useful work, you're not as worried about someone stealing it and you not being able to take credit or to, make any money off of your creation. Copyright registrations and protections provide some attributes of private property. And I'll talk a little bit more about that, especially when I talk about licensing and things like that. And it also allows creators to control, how is their work going to be used? How is it going to be making money? Um, for example, if you're an author, are you making sure that, this your book is in libraries as well as for sale, like online, as well as for sale in private bookstores, you get to make those decisions. And copyright protections help um, satisfy these concerns for creators. Like, how are they going to have control? How are they going to make money? How are they going to use their property? And do they even want to continue to do this work if it just gets stolen from them as soon as they publish something? So this is going to be the big goal, or most of the goals that go around creators. On the next slide, we're going to talk about society. So a goal to protect society includes that, copyright protection is limited. We have the works now from 1929 that are out in the public domain so that everyone can access them for free. They can use them. Like one little factoid that I think is really fun is if any of you ever watched Looney Tunes when you're a kid, especially the early Bugs Bunny works, like you'll have like these beautiful classical music in the background. Like I learned so much about classical music from Bugs Bunny cartoons and still recognize some today, like the Flight of the Valkyries or the Blue Danube. And the reason why Looney Tunes did this is because they couldn't afford um, to pay musicians to do background for their work. So they went into the public domain, and that's how they got the background for their cartoons. Also, copyrights only protect the form that you have put your creative expression into. Like they're protecting that creative expression. They're not protecting the facts. They're looking at how you're putting things together and what the final result is, and not necessarily all these other pieces. So other artists or musicians who are inspired by your work might take certain elements out and reform them and create something brand new. So copyright protection doesn't protect every single thing. There are parts that are available for other people to talk about, to use, and maybe to create something new with. Copyrights, like I already said, they come into the public domain. And then we also have exceptions for fair use that I will talk about some more. They're really important. And actually, I'm going to talk about them right now. Let's just go into it. So, fair use is actually a legal defense to people who are suing. Like, say, for example, if Disney sued you and said, you are infringing on my Mickey Mouse character, you could say, no, 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 my use is fair. I'm using this for fair use. For example, if I was using their original Minnie and Mickey Mouse that came out into the public domain this year, that would be, it's in the public domain, they can't do it. They can't sue me for infringement. But for fair use, courts tend to look at these four factors. Like, what is the purpose and character of the use? Like, say, for example, if something is commercial versus non-commercial, if I'm just using things for educational purposes and I'm not making a profit off of them, the court's more likely to say, this is fair. If you're using something for commercial profit, you are much less likely to be operating within fair use. So if you are using something in your business, whether you're using classical music in the background of some of your videos, or you're doing some of this, you want to look at these four factors to see if what you're doing is okay. You also want to look at the nature of the original copyrighted work. Like, is it more factual versus is it more creative? Remember, we said facts aren't copyrightable. So if you're just pulling out facts from a creative work, then you're more likely to be found to be engaged in for fair use. Also, the amount and substantiality is just like how much of the work are you using? For example, like, are you like just using a little bit of it, like a logo or like the way something is laid out to talk about it? Are you using like every element of someone's, book? Are you using the whole background of someone's musical piece? How much of this are you using it? If you're only using a little bit in connection with other purposes that are okay, you're probably going to be fine. If you're using a lot of it, you might be in trouble. They're also going to look at the effect on the market, like the fact that someone else is using part of your creative work. Does this decrease the demand for, your book or your album, or your artwork? Are they in competition with you? That can be a really big deciding factor on whether or not you've got fair use. But I've gone through all of these like kind of ideas, but really what it boils down to is are you using it for a commercial purpose? Like, is it making you money? Are you using it to comment on something, to use something for educational purpose? Are you using it to criticize something? And then probably my favorite is parody. And parody is when you're kind of poking fun at something. And on the screen, I have these dog toys that are called Chewy Vuitton. And this comes out of my absolute most favorite lawsuit of all time. It happened, gosh, I think back in 2007. But basically, this company started doing all these dog toys that they called Chewy Vuitton, and they carry over some of the design from Louis Vuitton. And Louis Vuitton got big mad. And they sued Chewy Vuitton, and they're like, no, you can't. Oh, it was in 2006. No, you can't do this. If you are kind of a dork like me and you'd like to see the decision on this case, you can actually just Google. It's called Louis Vuitton versus Hot Diggity Dog, and hot is Haute. But it's quite silly. The court really goes into these four factors and comes out and says, you know what? No one is going to think that these dog chew toys are Louis Vuitton purses. There's no likelihood for confusion. They're not taking anything out of your market. They've pretty substantially changed things. They've only kind of made a riff on your name and like taken a little bit of your pattern. Um, and you know what? In fact, I think this is parody. Like, this is poking fun at Louis Vuitton and this whole idea of like, these very high value goods. And here's some chew toys for your dogs. So the court ruled in Hot Diggity Dog's favor based on fair use and parody. And you can go out to Hot Diggity Dog online to this day and buy some Chewy Vuitton toys for your dog if you like to. So that's where this comes out. I think it's really fun. If it's something that you're interested in, I definitely encourage you to go look at that case. I think it's pretty accessible, and kind of silly too. So, other things that are not protected, I've kind of harped on this already, but ideas are facts. Some examples is like maybe you read like a copyrighted article, like a news article, and maybe you want to describe some of those facts in your own work. You can't reproduce the actual text without getting permission or having fair use. But if you, like, say, for example, a news article lists out some statistics and then you repeat those statistics and maybe create a graph or something yourself, you're going to be fine. Those are just the facts. But if you like copy and paste the author's paragraph into your work, um, you could get in trouble, unless you've got fair use. Like, for example, for students, maybe they make sure that that everything's quoted and they fairly attributed the words to the author. And that's for educational purposes. So it's kind of like fair use, but they're also doing some other things to make sure they're being clear that this isn't their words. But also, like, there's just like a lot of ideas that kind of get repeated in different stories or different expressions over time. Like, if you saw a picture of a dragon in a book and then you decided to draw or paint your own picture, or write your own story about a dragon, as long as the dragon didn't look exactly like theirs or the story wasn't exactly like theirs, like, you can have that idea to do something about a dragon and do that because it's the creative expression. Like, dragons, just dragons by themselves, that's like an idea or a fact. That's not something, there's no creative piece to it. Um, Also, some other things that aren't protected by copyrights are things like names, slogans, or short phrases. However, if you are worried about protecting these, they might fit under trademark law. So it might just not be a great fit with copyrights. Copyrights are a little bit of a different animal um, than trademarks. And I recommend if you're curious about this or you are worried about how it applies to your business, that you speak with an attorney about that. All right, so let's talk about how long these last. So, um, who owns the work? If it's owned, like it's kind of based on who owns or creates the work. So if the creator or the co-creators of the work are like artists, writers, musicians, the basic term of a copyright is the life of the author plus 70 years. If you have a situation where a company or an organization hired someone to create the work and it's a work for hire, then the Copyright Office says you can have the copyright from 95 years from the publication, or if you created it but didn't publish it for a while, you get up to 120 years from the date of creation of the work. And then also, just to kind of like make this even a little bit foggier, you can have situations where someone is using a copyright and it's because it's being licensed to them, or maybe they've purchased a copyright, maybe a piece of artwork, they want to be the original owner. Um, and then you have a written agreement to sell that copyright to someone else. Some places where I've seen this very commonly is like for maybe some of my graphic design clients. You know, they might create logos, they might create other artistic pieces or things for clients. And the clients are like, hey, I don't want to just have this this one, drawing or this one piece of artwork or what have you. I want to have this forever and I want to make sure no one else can do it. And so usually what will happen is within the service agreement, the graphic designer will assign the copyright over to the buyer. Whether it's the person who is buying it for their business, for example. And then usually this costs a lot more than buying a painting because you're going to be the only one who owns that work. Just make sure that it is in writing if you do anything like this. Like I encourage my clients who hire graphic designers to like maybe like create their logo, for example, that they have a purchase agreement so that they own all of the rights and they can go out and trademark it and use it and not have their logo show up for some other business at another time. So this is where I tend to see that. Copyright notices are very helpful. I think you should go on your artwork, it should go in front of your books, it should go on your software, and it should go at the bottom of your websites. So on this slide, I've included a nice copyright notice that you could use yourself if you like. And like Dan said, we will be sharing a PDF of the slides later, so you can take a look at this and make sure that your copyright notice matches with this. I just want to check, do we have, like, I've been kind of moving forward on a pretty steady clip. Does anyone have any questions? Okay, I'm going to keep
I,
on.
I have a question.
Yeah, please.
About the last slide. Would you explain more how actually proceed with that?
Like which part of the
The
slide?
the copyright that I think that you send
Oh,
yeah,
it's on this
yeah.
slide at the very bottom. I'm sorry, you're muted.
Yes, I think it was, yeah, that's the no, the next slide. Yeah, this one.
Yeah,
That
sorry.
you attach the file as well.
Yeah, so it's copyright, and then the symbol is a C in a circle, and then you want to put the year that it was created. So for example, I made up the slide this year, so I'm putting 2025 in there as an example. Then the name of your business or the artist, depending on who the work is owned by. So the Small Business Legal Clinic owns the rights, any creative rights to the slide. And then all rights reserved is kind of like a nice, kind of puts everyone on notice that you're not granting them any ownership or any license, like that the owner is reserving all of the rights to the copyright. And this is just an example you could put in, if you created a work last year, you could put in 2024 and you can follow it up with your name or the name of the business.
And is it, it's a long document. Is it something that we can actually use when we buy a copyright? So for example, some literature, just we buy it because we want to translate and publish it somehow.
Yes, you can definitely. What I do recommend, make sure you've got that copyright purchase in writing so that you own it. It's not required, but you can file the transfer of ownership with the Copyright Office. And then you can put your own copyright notice. Since you now own the copyright, you can put your business's name as the owner of the copyright. It's whoever owns the copyright.
Thank you.
Yeah, you're very welcome.
Shanna, we got a question in the chat. Will the copyright work internationally, for example, outside of the US?
So it really depends on the treaties that we have in place. So US copyright law is, like all of the things I'm talking about, is for the 50 states and the US territories. However, the United States has signed intellectual property agreements with other countries. So like, for example, the EU is like a very solid partner with copyrights and trademarks. There might be different ways you could go about registering. Like, for example, Amsterdam might have, like, I know they do a lot of patent work in Amsterdam, so I'm assuming they might also have a lot of other intellectual property offices there. If they were the ones, for example, who handled copyrights for the EU, they would likely recognize the US copyright because of the treaty. But then there are also options to file for a copyright registration that would cover the EU or other countries that we have the treaties with. So it's kind of like on a case-by-case basis. What I will say is that more recently, because of the tariffs, China has decided not to be as protective of United States intellectual property. That includes copyrights and trademarks. And that might change again if relationships improve. And then some countries also have like just different values and expectations around intellectual property. For example, I had a client from India, and he told me it was very difficult to protect intellectual property there because culturally, copying someone else's work was viewed as a very high compliment, that it wasn't necessarily a negative thing like we view it in the US. So it's going to vary kind of country to country. But if we have a treaty with them, those countries will protect our IP as well. Yes, please. I see you've got your hand raised.
I just wanted to actually add and also maybe get confirmation. I think that recently a TikTok platform, at least they or um, um, uh, Alibaba, the website. So
Oh, yeah.
they kind of are concerned about copyright. So it's the fake, let's say that Louis Vuitton bag, they do not sell it. So, or they do not produce it in Alibaba if you order. But probably there are black markets they do in China.
Mhm.
But recently they're a bit concerned about that. So I'm assuming that there are some treaties or something they're concerned about that.
For sure, I think it's as on a case-by-case basis. I know that companies who have already been sued are much more careful. So, for example, I see Amazon, Alibaba, like some of these sites being like, you know what, you've got to show me your trademark, you've got to show me your copyright registration before we carry this. So that might be something that that might be a reason that you decide to copyright your work for sure.
Shanna, there's
Yeah.
another question in the chat. Is there a
Mhm.
copyright registry or you can put the notice on anything you generate?
So there is a copyright registry. So you can put, but you can also put the notice on anything you generate. So here's the interesting thing about copyrights. Copyrights are in the United States Constitution. We've protected them from the beginning. We only started protecting trademarks in 1948 with the Lanham Act. So copyrights are so important that even before the registry went live, um, we had copyright protections. The thing between the registry and so you can put this on any of your creative works, this copyright notice. The registration provides you with additional benefits. For example, if you register, you don't have to prove as many things in court to show that you were the creative author and the original person who did something. So it makes it easy if there's like an infringement case or something like that that happens. Or if you're one of these authors suing Anthropic and you want to show that you wrote the book, having that registered copyright really helps. Also, you cannot file a lawsuit in US court until you have at least started the registration process. If you already had a registration in place before someone infringed, you could get up to treble damages. And that just means like, say, for example, if I stole something of yours and I made $10,000 and you already had a copyright registered before I stole it, you could show this to the court and the court would make me pay you $30,000. So there are a lot of benefits to doing the registration, but you do not have to have a registration. It's by the US Copyright Office. You do not have to have a registration to have protections, but it will make your protections more solid and will make it more likely that you could stop other people from infringing on your work if you have the registration.
Shanna, I put the copyright.gov in the chat. Is it to search the copyright records under
You
on
can
that one?
search, yeah, the website include so let me just gush a little bit about the copyright website. So trademarks are run by attorneys, and I will own that we make everything more complicated than it has to be. It is not very user-friendly at all. The Copyright Office is in the Library of Congress, and the whole site and the whole program is run by librarians. So everything, they have everything on their website. They have a registry. You could message them and ask them questions. They have how-to videos that are really clear and helpful if you want to register your own work. So you can definitely go to copyright.gov. I've got an example of their page for visual arts. So they have different application forms based on the kind of work that you want to copyright. So they have like a different form for music versus a different form for literary works versus a different form for visual arts like paintings or sculptures or things like that. And so if you're interested in registering your copyright on your own, I think it's much more straightforward and easy to do than if you tried to do a trademark on your own. You can go to, like, say if you had a visual art, you go to the Copyright Office, you could go to the registration portal and look at all of these different visual arts. They'll have a lot of education about them. They'll have how-to videos. So basically, you can go through and you can do it on your own. I've also helped clients register copyrights as well. So we just kind of go through the process together. You have to have a digital copy of your work. That is kind of nice because before COVID, they made you mail things in and triplicate. And that was a big pain in the butt and could be very expensive. But after COVID, you could just upload like a PDF, a JPEG, an MP3, what have you, to show your work. The registration fee is not too expensive. Like trademarks are $350. A copyright registration fee could be $45 to $65, depending on what kind of copyright you're doing. And then you can just create an account and register your work. But yeah, you could work with an attorney or you could do this on your own. It's definitely something that's pretty user-friendly, and they try to be as helpful as they can on here. Does anyone have any questions before I move to the next?
There's a question about the registration fees, Shanna, but it seems like you're covering it.
Okay. Yeah, I think on average, I see 50 to 55 is what I usually see. But it kind of ranges between 45 and 65, kind of depending on what kind. Like, for example, if you are copywriting a whole bunch of works together, usually you copyright one thing at a time. But if you have unpublished work, like say, for example, you're an artist and you have created, like 5 or 10 paintings that you're going to put in a gallery, because a lot of times when you have a gallery opening, the artwork is kind of related by a theme together, and you haven't published it yet, you could actually apply for a copyright that would cover that entire, those entire like 5 to 10 paintings. Or if you're creating like, a whole album, instead of copywriting one song at a time, you could copyright like the entire album. And there's just a couple of extra rules around those, but they do have education on the website about what those rules are. And that's usually when I see that higher $65 fee, is when it's more than one work at a time being registered. Okay. I'm going to trot on now to talk about licensing, because it's kind of like ownership, but someone else holds the original copyright and you just have a couple of pieces of it. So, copyright ownership is like a property right, but it's kind of fuzzy. It's really helpful to think about copyright ownership like a bundle of sticks. And each stick is a different kind of right. So if, for example, you owned everything, you own the entire bundle, but what if you want to license the right to play your music like on the radio, and you work with like a music catalog to do that? You're probably pulling a couple of sticks out of the bundle and handing them over. There is a big long list of sticks that you can decide to keep for yourself or to hand to someone else for a fee, and this is called licensing. Does need to be in writing. But the most common things that I see is like, how is the other person allowed to use something? Are they the only one allowed to use something? Or are you going to allow multiple people to use something? Where in the world are they allowed to use the thing? Are they allowed to use it anywhere in the world? Or are they only allowed to use it in Oregon or in Portland, for example? Like, where are they allowed to use the thing? And another really big question is, can they modify it? Like, are they allowed to change things? A really common licensing issue that I see, for example, is someone has a creative work, but maybe they are producing it um, in partnership with someone else, and the other person wants to make sure they've got a license so they could take like a still shot of a film and use it to advertise, for example. So there is actually a much longer list of different sticks, but I thought the slide was looking too busy, so I just wanted to talk about the 3 major sticks. But it's really helpful to think about, like, not only can I use it, but I can allow other people to use my work for a fee, and you can decide how they get to use it. Do they get to use, you know, most of the sticks, half of the sticks? You get to have that decision. I really recommend working with an attorney, whether it's with the SBLC or a different attorney, if you decide to license your work, or if you are a business who wants to license someone else's work, whether it's software, photography, art, literature, or music. So, but this is a really nice thing about copyright ownership, is it can be produced over and over and over again. And in fact, it's meant to be shared with as many people as possible while still like paying the creator or the artist. Okay. I want to have like a little moment about protecting your copyrights online, because it does get to be a little bit tricky. One thing that if you are a company that posts other people's work online and you don't have a direct license with them, or if you're posting stuff and you think the person gave you permission, but you're not sure if they're the original artist, sometimes people lie. There's something called the Digital Millennium Copyright Act. And the major thing that they did is they provided a notice and takedown system. This protects companies from being sued for infringement because they put a notice in their terms and conditions. This is how you can reach us and ask us to take something down. And then it also protects artists by allowing them to have a really easy process to reach out to companies and say, hey, I found my work on your page, you've got to take it down. So if you are a company, what you have to do is you have to designate the specific person who does the takedowns and who the public can contact to take something down, and you have to register them with the US Copyright Office. And then as if you're the artist or the creator, what you can do is you can write this person the notice, and then they have to take down the thing from their website. There's a lot of guidance from this at the Copyright Office, including big long templates of what has to be in the notice and things like that. They're very helpful. I will say that if you find your work on someone's website and they do not have this DMC notice, and you sue them successfully for infringement, they're going to pay a lot more money. Like litigation attorneys who do copyright work get all giggly and happy when they find you don't have a DMCA notice. So if you have any work from other people, whether you're pretty sure that you own it or they own it, I would just make sure you've got a DMCA section in your terms and conditions on your website. Make sure you register that agent. It could be yourself. And then if you're an artist or creator, I recommend setting up like a Google notification where if they find any specific identifiers, they send you a notice so that you can know if someone else is posting your work. And then just get familiar, know that you have rights and you can ask people to take things down. So that's something that I wanted to post. I think it's pretty important to my creative clients to know that if they find their comic or music or something on someone else's website online, that they do have some rights. Not all of us have money to go to court and sue someone. So this is a nice way to like be able to stop infringement without having to, involve attorneys or pay a lot of fees. Okay, I am about to dive into how artificial intelligence makes everything a little bit more complicated. Does anyone have any questions before I start moving on, though? Okay, I'm going to move on. So I'm going to be talking mostly about copyright issues with artificial intelligence and then a couple of things that we can do to notice them and also address them. Um, Unfortunately, not everything is straightforward. Um, Artificial intelligence is going so fast that the law is not really able to keep up with it. And so, for the most part, the major issues with how artificial intelligence is interacting with copyrights, whether it's someone else's copyrighted work or AI is trying to create new creative works and get those copyrighted, we're mostly seeing this fall out in the courts. And since most of us do not have the money to have big lawsuits, we're watching the New York Times, we're watching Disney, we're watching all of these other really big companies take on Meta, Google, all of those different big AI companies. So there's a ton of lawsuits out there. And what I'm finding the biggest issues to be are first, unauthorized use of copyrighted material to train AI. Second is digital replicas. And then third is like, hey, I used AI to create something. Can I get it copyrighted? In terms of unauthorized use of copyrighted material to train AI, like this is sometimes called generative AI training, courts are pretty split, but they are mostly finding it okay to train AI, but they will consider whether the outputs that aren't just facts, but have creative expression infringe. And they'll look at like, those fair use for factors and things like that. I will say though, is like the biggest decisions are happening on the East Coast and the West Coast. The West Coast courts, especially in California, are finding that most generative AI training is fair use. However, most of the courts on the East Coast are finding that it's infringement. So we probably won't have a definitive answer to this unless the Supreme Court weighs in. They're probably going to at some point because we have different courts across the country coming to different decisions. But it kind of is looking like if they're just training the AI and they got your work legally, then it's okay. But we will see. Digital replicas are when this has become a really big issue where someone has maybe done a video or made an image or an auto recording, and they've created it with AI, making it look like a person, like a celebrity or a politician, is saying or doing something. It is a very interesting area because like politics and national security are involved when we're talking about if politicians are made to look at like something, we're looking at copyright. If someone is changing, a work and making it look like someone's like comic or music or film was doing something that they weren't supposed to be doing. So it kind of overlaps with a couple of things. With digital replicas, the courts, especially of copyrighted works, the courts are just doing a regular, is this infringement? Is there a defense of fair use? And deciding whether there's a copyright infringement or not. For deep fakes, when they're specifically using human beings, these lawsuits are mostly falling under the right to publicity, which is a different kind of intellectual property. But the waters are muddy. You might see court cases where they're talking about digital replicas and deep fakes in the same hand, and they're just a little bit different, but I don't know that they're different enough that you need to worry about that. Just kind of know that there could be different kinds of intellectual property involved with that, and that law enforcement agencies, especially when you're talking about a human being made to look like they're doing something, are taking this pretty seriously. And then also the last one is just copyrighted of AI generated works, which I have a whole slide on. So if you're interested at all on how the courts are doing things and you just you want something kind of laid out and summarized for you in a really straightforward way, the Copyright Office has started printing out reports about AI, artificial intelligence, and copyrights. They've got a three-part report out right now, and they're basically summarizing the outcomes of the court decisions and saying this is what the law is going forward. So you can look those up online. But what these reports summarizing the court cases are basically saying that is if you use AI to create something, music, a painting, a work of fiction, copyrights and registrations are only issued to human beings. So AI generated content might be okay if you're using it like a tool, but the human being has to be able to control and determine all of those creative, expressive elements. And courts have specifically said that entering prompts in is not alone. Like just prompts, that's not sufficient. You're not going to be able to file a copyright for just putting in prompts and creating something. An example of something that you might be able to copyright would be like if you had a photograph and you wanted to touch it up and you used an AI program to help make the colors different, sharper, completely different. If you were using the AI as a tool to kind of tweak the picture to make it a bit different than the original, that might be something where you started with your original work and then you're just tweaking it to use AI, tweaking it with AI. That might be something that you could still get a copyright from. So that's just really important to know. Like, for example, if you are thinking about using AI to create yourself a logo, if you're just using prompts, you're not going to have ownership of your logo. Other people could use the prompts to create that logo and also have that logo. It's not going to be copyrighted. And then also whoever gets a trademark for that logo, it's probably going to be a race to whoever can trademark it first. So just be really careful with works if you're using AI and you want to be able to have rights to the things that you create with AI. Just know that this is there. There's these reports that are available. They're really accessible. I think they were in pretty good plain language, rather than, having to try to sift through news articles describing court decisions or things like that.
Shauna, there is a question in the chat, and I don't know if it's something that could be discussed offline, but the question is there any reason to copyright a whole business plan? The person is using a software that helps generate a plan via prompts.
I would have to know a lot more about those facts. And I think this might be a question that you would probably want to work out with an attorney specifically. It's possible you could get a copyright. It's possible that you may want to copyright it. It's possible that this might be better protected as a trade secret, but it's definitely something that you might want to talk with an attorney about. So for the last few slides, I know that we're kind of coming up on time. The last few slides, I want to talk about if you are a creative. So if you are a visual artist, a musician, or a writer, I want to talk about steps that you can do to protect your work from AI. Because I know that unless you're Disney or the New York Times or one of these like big music catalogs, you probably don't have the money to be going after these AI companies. So here are some practical things that you can do that could help protect your work. The first thing I want to mention is if you are, this whole slide's on visual artists. So if you have to leave, I understand if I go a little over time. But if you're one of these kinds of artists and you want to stay, please stay. For visual artists, the University of Chicago students developed something called a glaze. And the glaze is free. And what it does is it subtly changes the pixels to make it really hard for AI to copy an artist's style. So you basically download the software and then you run your visual art through it, like a picture of it or whatever. And then you upload that picture with the glaze on it onto like your website or into social media. On the bottom of the screen, I have examples of what the glaze does to a piece of artwork when when AI tries to copy it. So the very first picture on the left is just a piece of artwork with no glaze on it. It's basically the original artwork. The second picture is what AI sees under the original glaze. They've also updated their code. So the third picture, the farthest one on the right, is what AI sees. If you're using their upscaler as well, because they're always trying to stay ahead of AI. So you'll probably see new versions or upscales of their code offered. Again, this is students doing this with professors. So it is entirely free, but you can see how different that work looks versus the original one on the left going right. You can also put digital watermarks and copyright notices on your work if you're posting them on your website. Like, remember that slide where I said copyright C in a circle 2025 Small Business Legal Clinic, all rights reserved? You could do that as a watermark across your art before you post it on your website. And that really cuts down on theft. I will say that my clients have reported having problems posting on social media and advertising on social media if they have a watermark. but they have not had problems using the glaze. And I think it's not necessarily that their work won't upload, it's just the algorithm won't push it out to your potential clients. So that's something that is really easy to do, probably with software that is free, doing the digital watermark or doing the glaze, but I do recommend, taking those steps. There's also something that you can do, especially if you have a digital work, to mess with the metadata. You can change the metadata so it makes it harder for AI to upload it, but also you can put in your ownership information. Like you can put that copyright notice in so that they can't download the artwork without being able to see who owns it. That's generally going to be something that you program in if you're a digital artist within the digital software that you're using. You can send that DMCA takedown notice if you find your art on any websites. And like I said before, I recommend setting up Google Alerts or using some monitoring services so you can find out when folks are using your work. So my next slide is focusing more on musicians. So I do want to say that if you are in Tennessee, but unfortunately this doesn't cover the entire country, Tennessee was the first state to pass a law that makes it illegal to use AI to copy an artist's voice. They're really big about their musicians in Tennessee. But seeing some of these laws come to be, it makes it easier for other states to adopt similar laws because they can kind of look at Tennessee's and basically copy and paste what they need into theirs. Funny thing about anything produced by the government is it will not be copyrighted. Even creative works created by states or federal governments are created using our tax dollars. So those works aren't copyrighted, and you could totally copy and paste Tennessee's law into Oregon law if you wanted to have these protections for musicians in Oregon, for example. AI or musicians and writers have been really good about doing strikes. Like we heard a lot of news early last year about the writers' strike to help make sure in their contracts they're protected against being replaced with AI. Musicians are also working with music catalogs that collect their royalties. Some of these catalogs are really big, so it kind of gives them a position where they have the leverage that the big companies have because they're all using some of these couple of music catalogs. The University of Tennessee created a free program called Harmony Cloak. And what it does is it inserts tiny sounds that cannot be heard by the human ear into music so that AI cannot steal it and copy it. When AI tries to get it, it hears all of those tiny sounds. There is some congressional legislation out right now. For example, I found the No Fakes Act. This mostly goes towards, copies and deep fakes and things like that. There were a lot more bills last year, but my understanding is that this administration is pretty pro AI. So I'm seeing a lot less federal legislation coming through to protect individual artists, for example, against AI. But that is one bill at least that I've seen this year. Okay, and the last big slide I have is just for writers. So, the writers unions are also striking. That's really helpful. There has been a really interesting class action lawsuit against Anthropic that initially led to a $1.5 billion settlement. However, right after they announced it, a judge said that he didn't think that they were allowing the writers enough say. And so he was making them go back to the drawing board. But when the settlement goes through, it will kind of set more of a baseline for more writers to understand what the damages are. The Anthropic lawsuit was basically a situation where Anthropic engineers went onto a website that pirated authors' work and downloaded all this pirated authors' work to train their AI. And because that was pirated, they were getting, oh no, this is infringement right out of the gates. So at the very least, until we know what the final decision is going to be and what the settlement will be, at the very least, we will see AI companies be a lot more careful on where they get the works to download and train their AI. There are some no AI training notices that you can write. It's really hard to say whether these are very effective, but it at least, kind of puts people on notice, kind of like the copyright notice that you would put at the bottom of your website or in the beginning of your book, like, hey, this is copyrighted material. I'm not okay with AI training this. If they do it anyway, that might help in some of your court arguments. Some websites are also allowing you to block bots from different AI. A really common one is there's a lot of websites have a blocker for GPT bot, which is from OpenAI. It's this text file that you can download, but I think most of the time I'm seeing it through like different companies that host websites, for example, like GoDaddy or SquareSite, looking into their terms and conditions and seeing if there's this option to block the bots from even being able to access your website. And then just like with visual arts, you could also do digital watermarks of your art. There are a couple of softwares available, kind of like Glaze and the Music Harmony one. However, I don't recommend them to my clients at all. And the unfortunate thing is what happens with the written word in those different software programs is that it'll interfere with accessibility programs. So if you have someone who is blind and using a software to read your website, those things for the written word will unfortunately mess with those accessibility softwares. And then the person won't be able to read your website at all because their software program can't access it. I think that there are developers that are trying to work on this problem because, of course, we want everything to be accessible, but we also want to try to protect writers. So I think they're trying to work on this, but it really has to do with them being able to say, oh, this is an AI bot instead of this is, like a human being using software to access the website for accessibility. So that is more tricky for writers. Unfortunately, they are out there, but I don't tend to recommend them to my clients. Okay, so thank you for bearing with me, especially since we started a little later and I'm finishing a little later. I would love to have any additional questions you have, but I also want to be respectful of your time. Okay, well, if no one has any other questions, I just want to say thank you so much. I hope this helps with both your decision if you're an artist or if you're a business who is making sure your terms and conditions are updated or you want to work with artists or writers or musicians. I hope this is really helpful for you. It's been my pleasure to give this presentation and answer questions.